Helga is a senior lecturer at Anglia Ruskin University Law School, and her research is focused on human rights, environmental law, and the issue of multinational corporations and vulnerable workers. In 2017, Helga presented her paper on multinational corporations and human rights at the annual conference of the Society of Legal Scholars in Dublin. And in 2018, she became a member of the professional training for lawyers and barristers in the United Nations Guiding Principles in Business and Human Rights Working Group. Helga's vast research experience into the impact of global corporations on human rights was the main reason why we invited her to give a keynote speech today and to open up the area's first ever Sustainable Fashion Week. Just a note, once again, if anyone has any questions, please feel free to ask them in the chat because I will be constantly monitoring it. Helga, I will hand over to you now.
Thank you, Kate, and hello, everyone. I'm really happy that I could be the first speaker. As Kate said, I worked on the topic of human rights connected to environmental law and fast fashion. So I'm really glad that I can offer you a little bit an insight of my research today. And so I'm going to talk for about 40 minutes, and then I will let you ask him some questions. I'm going to share my screen as I prepare some PowerPoints for today. Here we are. So the title for today that I thought that could be interesting for you is Corporate Social Responsibility and Fast Fashion in International Law. So as probably you can guess from the title, the way in which I want to tackle this difficult issue of human rights and fast fashion is from this international law perspective. I can tell you why, because mainly at the moment, international law is the main way in which we can contextualize the problem of corporate social responsibility. It's the best way at the moment in which we can contextualize corporate social responsibilities, because we have significant legislation which is called is not a proper legislation. It's called soft law, but I will tell you more about that later. But it's called Guiding Principles on Business and Human Rights. So we have a guideline at international level that actually is telling us what we should expect from companies and how they should behave with regard to human rights. So this is more or less my context. So I'm investigating on human rights in transnational corporations and their subsidiaries. And this is the main point. The point of supply chain, as you might have heard already, is one of the critical points because it's very hard to regulate and to monitor as well the supply chains which are located in other countries, but which are still under the control of the main corporation. So my area of the research is exactly that. So I'm going to focus on transnational corporation within developing countries, within countries in which the production has been relocated. I thought might be interesting for you to, so I put a tag here, hashtag, it's called With Human Rights, which you can use in order to know more on Twitter about this fantastic world of business and human rights. So if you want to know more, you can go and have a look on Twitter and see all the type of articles and all the type of debates that are actually going on the topic. But let me give you a little bit of historical background. So why this is a controversial topic, why business and human rights are connected, why there is not sufficient control on that. Well, the main problem here is that companies are companies, they're not states. If you have some familiarity, if you know a little bit international law, you probably know that in the best definition of international law is for states. States are actors of international law. So companies are more or less considered also as part of, as actors of international law, but they're non-state actors. What does it mean? It means that the international community recognize some powers to them, recognize some sort of possibility of moving a great amount of people, moving a great amount. Sorry, there's a lot of things moving here. It recognizes power basically, but they don't have the same responsibilities in the same way that states have. So you can see I put a little bit a sort of a timeline in this PowerPoint in which we start from the Universal Declaration of Human Rights, which was made for states. If you have some ideas of what is the Universal Declaration of Human Rights, you know that is basically the main document that we have protecting human rights. It was drafted in 1948, is a declaration, so it's not binding. We cannot enforce that in a court, but is our main guidelines in terms of human rights. But unfortunately, this was mainly for states, was not for companies, was not drafted for companies. So this is the main point from which I want to start today. The idea that companies do not have this international personality, let's put it in this way. But in 1990, we finally start to recognize that. We started to recognize that mainly because the relationship between business and human rights concerned oil, gas, and mining companies, which actually were expanding and were creating difficult situations, especially because they were practicing this offshore production in clothing and footwear. And this was drawing attention to poor conditions in the global supply chains. You might have heard already about the Nike situation, for example. So this idea that in the supply chain, companies were allowing lower standards, lower protections of human rights, actually raised the problem that possibly we need to make them responsible as well as it happens for the states. So in 2004, and this is the end of my timeline, we have the draft of norms on the responsibility of transnational corporations and other business enterprises with regard to human rights. So this is a long title, but this was the starting point. It was actually drafted by the subcommission of the UN Commission on Human Rights. And this is actually, these norms were trying to impose binding obligation on companies. Now you can imagine how hard it could be to enforce rules, international rules, binding rules on companies. So that's why the situation was a little bit complicated. It was very hard. Again, the problem here, the problem that I wanted to highlight here is that we cannot really enforce legal obligations, international legal obligation on private companies. They're not states. They're not actors, former actors of international law. And this is the starting point. This is the main issue. The main issue is especially related to the concept of transnational corporation. What are transnational corporations? Well, here you have a definition. They are incorporated or unincorporated enterprises comprising parent enterprises and their foreign affiliates. What does it mean? In simple terms, this means that we have a company, like think about in general terms about the company, the most traditional idea of companies. Well, the headquarter is generally placed in an economically developed countries, and the production is relocated in developing countries. This actually creates several cross-border operations, which to some extent is what actually creates the advantage of having the production relocated, because thanks to lower a lower cost of the workforce, we this type of corporations, they can actually manage great profit. So I'm focusing, my main point is exactly to focus on this type of corporations. They can also be called multinational corporations. And we can possibly generalize the fact that their relocation is in this region of the world, like Asia, Africa, and South America. The question is whether we can really apply an appropriate legal framework in order to contain this human rights exploitation without compromising the economic advantages that actually this type of corporation create. I'm not saying that they are absolutely evil, but I'm saying that actually they create some economic advantages. This type of advantages derives from this global world's economy. So the question is, how can we create legislation capable to to enforce human rights, but at the same time keep the economy free to flourish? This links to the concept of corporate social responsibility that you might have heard already. So it's very hard to define corporate social responsibility. In general terms, we can say that is the idea that companies should act in an ethical way. So the problem here is that how can we enforce that? How can we ask transnational corporations with all the elements I mentioned before? So with the fact that they have relocated production, with the fact that actually they create profits through a globalized globalized market. So the question is, how can we ask for how can we enforce corporate social responsibility for this type of companies? And this type of companies, I just want to give you maybe some examples, are very famous. It could be Coca-Cola, it could be H&M, it could be Zara. So companies that you will see that they have several, they mainly headquartered, for example, in Europe, but they have the production relocated somewhere else, and they're quite widespread around the world. So the question is, how can we respect, how can we enforce, how can we impose on such corporation human rights? They would definitely, they would not accept international regulation on private entities. This is given for granted. We cannot expect to impose international law on private entities. So the idea that has been developed by Carroll's, for example, is this pyramid. This pyramid shows the elements that we should expect reasonably from transnational corporations. So we should expect legal responsibilities, which means that organizations should operate within the law at all locations in which they do the business. We should expect economic responsibilities, which means that any organization should deliver an acceptable return for shareholders while contributing to local and global economies through their core business. So this type of balance I was mentioning before, a balance between the shareholders, which are the people that have interest in the business, and at the same time, on the other hand, the contribution to the local economy as well. Then, as a third point, we could expect ethical responsibilities. What does it mean? It means that organizations should consider social and environmental impacts on their operation. And in this way, they should try to do not harm while pursuing their business interest. As a fourth point, we have the discretionary responsibilities, which means that we should include the positive social contribution beyond profitability. So in other words, this type of organization, they should have the responsibility to understand broad stakeholders, so the people that are affected by the business. They should understand their needs, and they should try to address the concern of the society through their business practices. So these are the points that in general terms, according to the concept of corporate social responsibilities, which is a general term that we can apply also nationally. But at the international level, this is what has been defined as the minimum standards in order to guarantee ethic behavior from the transnational companies. The problem is that these are still quite abstract terms. In fact, corporate social responsibility is very hard to apply, especially in supply chains. The idea is that, of course, there should be a rule that covers all the aspects of the production. So not only the headquarter, but also the supply chain. The reality is that it's very hard to enforce that. So what happened? It happened that in 2011, this idea of corporate social responsibility became a little bit more real. And it was embedded in this guiding principles on business and human rights for implementing the UN Protect, Respect and Remedy plan framework. So what does it mean? It means that the problem of corporate social responsibility on transnational companies has been recognized at the international level. In fact, John Ruggie was appointed. John Ruggie was a professor from Harvard, and he was appointed as an expert. And the UN asked him, please, could you define these rules of ethic behavior for companies? And this is what he did. This is the product of his work, the guiding principle. I will call guiding principles so far from now on. And these guiding principles have exactly the idea. The idea is to protect, to respect, and to offer remedies, which is one of the main issues. Offer remedies to the victims of the type of transnational corporation that are actually exploiting them. So the connection is definitely, this is how I intended, for example, we start with an idea of corporate social responsibility, and we intend the guiding principle as a developed version, an international developed version of corporate social responsibility. As I was mentioning before, when I was introducing the topic, the guiding principles, and this is why we are here talking about them, they have, of course, some problems they might create some problems in terms of application. Why? Because these are soft law. So now you might not be familiar with the term, but soft law is a type of law that generally exists at the international level, which means it's not strictly binding in its nature. So it's not directly enforceable. You cannot take a guidance from the guiding principles that you cannot bring into the court. You cannot ask to be enforced. You cannot ask the guiding principles to be enforced. So, and this is actually the reason behind this controversial choice of having guiding principles like that, because what they were trying to do at the international level is to find the compromise that I was introducing to you at the beginning. The idea to find something in between a strict legislation and a free market. The guiding principle fit this gap in a quite soft way, as the term let you guess. So what does it mean? It means that this guiding principle, they don't work, or they're just there for nothing. Actually, there are some recognized advantages, but the discussion is still whether they should try to transform them in a treaty. If you know a little bit about international law, an international treaty is still binding among the parties, but it has a voluntary you can voluntarily decide as a state, you can voluntarily decide to take part to a treaty, but it's much more binding than soft law. So at the moment, what's happened is that the guiding principles give us a guideline, a soft law, a code of conduct, let's call it in this way. They gave us a code of conduct for companies, which is actually, in my opinion, is better than a general definition, a general provision in terms of corporate social responsibility, but still is not crystallized and enforceable like a treaty. What is written in these guiding principles? Well, I wanted to to highlight 2 points. The first one is that these guiding principles ask states to protect the population. So what's happening is that they want to enforce a sort of precautionary effect. So precautionary effect is a quite strong concept in international law. It actually has been used as well in other contexts, such as the crime of genocide. So precautionary effect is the idea that we should prevent disasters before they happen. And therefore, this should be in the hands of the state. This should be the responsibility of the state. So changing a little bit, developing a little bit my point, the point I made at the beginning, that corporate social companies should have responsibilities like corporate social responsibility at international level. Well, the type of approach that the guiding principles are having is to focus also on states, not only on companies. And the idea is that states should protect in terms of preventing and directing what happened in their own country. The second point is the most controversial one, because the core of the discussion is whether companies are subjected to any direct international legal obligation to respect human rights. As I said, this is a kind of controversial point because the guiding principles ask corporations to have some sort of responsibilities. So they ask, but they cannot enforce. That's another issue. So while companies in this way are strongly encouraged, at the same time, they cannot be compelled. So as I said before, the guiding principles, they're not legally binding. And again, this voluntary nature in this term seems to be a little bit inadequate compared to the more business-oriented policies. So this is the issue I want to present to you today. Why we're here talking, why we can still see these companies making a huge profit with no respect of human rights, mainly because we can force state to protect citizens. We can only ask corporations to apply due diligence, and I will explain in a second what due diligence means. But this is the main issue here, and this is what the guiding principles are presenting to us: a sort of conflict and a sort of frustration between the possibility to regulate and the idea, the dream to regulate such business, and this situation that at the moment is quite widespread, globally widespread, and at the same time the impossibility to really do something because corporations are non-state actors, so they cannot really we can really enforce any type we can enforce any type of international law. So this is more or less what I said so far. So due diligence, as you've seen in my previous PowerPoint, is connected to the work of companies. So what does it mean? It's a little bit, I would say, a different type of concept compared to corporate social responsibilities. Due diligence is this idea that companies should identify and address the human rights impacts of their operation and products. And this is quite interesting because we are asking a lot. We are asking companies to we are giving companies responsibility, and we are asking them to keep the situation of human rights monitor within their business. So due diligence, according, for example, to Ruggi, Professor Ruggi, that I was mentioning before, he was the one drafting and developing the guiding principles. He said that the due diligence process should include assessing actual and potential, which I found it very interesting, human rights impact, integrating and acting upon the findings, tracking responses, and communicating how impacts are addressed. So a quite ambitious aim for such a soft law. More in detail, what we are asking to companies to cover adverse human rights impact. So we are asking companies to contribute to the promotion of human rights, and to do that through their own activities. We are asking them also to keep an eye, to keep monitor how human rights might develop. For example, the complexity of the protection should be applied in a different type of at the different level of the production. And still, there should be some updates and recognize that human rights risk might change over time, and the business should recognize that and should act. So as you can see, what we are asking is quite ambitious. And again, I want to emphasize again that we can only ask, we cannot enforce. In fact, the criticism, we have several criticisms to the guiding principles. The first one can be easily understood as the one I was mentioning to you, that corporation cannot be compelled as the principles are not legally binding. So the first criticism is connected to the fact that we are talking about soft law. We are talking about law that cannot really be enforced, especially against corporations which are not state actors, are not directly connected to international law, which is a type of law created mainly for states. Even though now we're recognizing the role of state actors, still applying that to corporation, it can be challenging. The second criticism, but these are just a bunch of criticisms I collected, there are much more. It's just to give you an example that the magic and the dream about the guiding principles is can be easily destroyed, especially because we are facing the problem of the economic challenge that enforcing a strict legislation would imply. So the second point is that states should be responsible for the violation of the territory. So that only state, this is actually a point connected to the first one, that only states should be held responsible, not companies. States are signing international treaties, are committing in the international debate, and therefore only states should be held responsible within the territory. And this is another issue because, of course, different states might have different type of responsibility, might have a different approach to the type of responsibilities. And I will give you an example in a minute. Another criticism is related to the territoriality again. In particular, what I said before, that transnational corporations are located in different parts of the world. So it's very hard to enforce, for example, legislation from one country on a supply chain that is actually based in another country. So this actually creates problems in terms of extraterritorial jurisdiction. I hope this is not a too difficult concept. The main point is that we cannot, if we have the headquarter in Spain, and actually most of the production is in India, we cannot go in India and use Spanish law in order to solve the dispute. So it's very hard to decide which type of jurisdiction we should apply. And this again was one of the issues raised in the case that I will mention in a minute. The other issue relates to the global supply chains. Of course, it's very hard to monitor what they're doing. Most of the supply chains are independent and they just provide the product required by the headquarter. And so it's very hard to investigate what is really happening, especially in countries in which the law is unclear. And ultimately, the point that I want to emphasize again, and that goes back on this idea of companies and the incapabilities of holding companies responsible at international level, is that the enforcement of human rights norms against corporation would actually depart from the traditional human rights practice. It would be something very different from the type of application we usually have of human rights. I was promising a case. I will talk about the case, the Buffalo case in a minute. Before, I want to talk about the Rana Plaza case, which is strictly connected to the fast fashion industry. So what happened, you might have heard that from the news because it happened only in 2013. Well, in 2013, there was a building, the building you can see in this picture, called Rana Plaza, and collapsed. This building was hosting 5 garment factories. So the fact that this building collapsed killed, at least from general records, 1,132 people and injured more than 2,500. The disaster was considered one of the worst industrial accidents on record. And to some extent, it created, created awareness in terms of the poor labor condition of the people that were actually working there. These people working, this Rana Plaza was in Bangladesh. These workers, they were forced to work in very difficult conditions, very long shifts, and no trade unions, no protections. So after Rana Plaza, so Rana Plaza was not the only one. Since the Rana Plaza disaster, no fewer than 109 accidents have occurred. So among these, at least 35 were textile factory incidents in which 491 workers were injured and 27 lost their life. This, of course, was caused by an absence of a well-functioning labor inspection and a lack of appropriate enforcement mechanism. So what we see here is an example of very low, a lack of decent work, a lack of dignity. And this is where the majority of workers in the garment industry and their family have to live with. This is a list of the factories that were actually involved in the Rana Plaza disaster, actually, let's call it disaster. As you can see, some of the brands are well known, they are selling their products in Europe, and you can buy a t-shirt for a very low price. But how much cost this t-shirt actually? if for you, you can buy a t-shirt for £5, this has a bigger cost in terms of human rights. The problem, the risk that we can see in the garment factoring are several, and here I'm listing just some of them. Well, we have discrimination against women mainly, because most of the women, especially migrant women, they are exploited and they're forced to work in this type of industry. Child labor is another big issue, especially because on one side, they don't cost children, they don't cost much. Actually, you can pay them less, and families are happy if children can bring home some income. So this is a quite difficult issue to tackle. Wages are way too low. Most of the criticism is that at the end, better a low wage than no wage at all. But at the same time, this low wage is justified by the high competition among suppliers. So the low wage is decided by this company's headquarters in developed countries, which are competing with each other in order to offer the t-shirt not at £5, but at £4.99. So even lower than usual, even lower price than their competitors. But this, of course, is at the expense of the workers. The other risk related to the other type of human rights issue related to garment factories is the lack of social protection. Work safety are mainly inadequate. We've seen that in Rana Plaza, but on the top of that, the daily challenges that this type of worker has to face is the fact that they cannot take sick leave. There are discriminations against pregnant workers. And most importantly, and this is something that was highlighted in the guiding principles, the fact that for any injuries, there is no remedy. This, before I go on with the last 2 points, is connected to the Bofal case, which I didn't include in the PowerPoint because it's not a case connected to the garment factoring industry. But I found it very interesting. Bofal case is a case from 1984. And consider that the last decision was in 2011. So it was a case that has been debated for such a long time, mainly because, so I tell you in a nutshell what happened. It happened that in Bhopal, in India, there was this Union Carbide industry, which was producing pesticide. At some point, there was a leak and 40 tons of poisonous gas was cover the all surrounded area. They found that nearly 3,000 people were immediately found dead and 50,000 people were permanently disabled. 50,000 people died after being exposed to this gas. But what is even worse is that this area is absolutely still poisoning. It's still unhealthy to live there. The soil is full of this pesticide after 36 years. The problem, and this is actually connected to the remedies that have been addressed in the guiding principles and in this PowerPoint are addressed like one of the main human rights issue. The problem is that all these people that were injured or the family of the victims, so the survivors, they didn't receive any compensation. Why? Because it was very hard to define how to solve how this legal issue should have been addressed in which country. In fact, at the beginning, in 1989, actually, sorry, before, in 1986, they started a lawsuit in the US because this was an US company. They started in the US, and actually in the US, they decided that this should have been discussed, the claims should have been discussed through the Indian legal system. So in 1989, the Indian Supreme Court just approved a settlement which was never paid to the victims and the survivors. So actually was paid only in a minimum part. In 2004, the Indian Supreme Court directed another fund for the victims, but these victims still were finding it very difficult to obtain the compensation that was promised to them. So what happened is that in 2010 they reopened the settlement, showing that they didn't really receive the money that they were promised to them. So they asked to have this settlement reopened, but in May 2011, so 1 year after, the Supreme Court rejected this petition and declined to reopen the case. So this is just to say how hard, despite Bhopal case, the Bhopal disaster is one of the worst disasters in the last 40 years, still offering and providing remedies for the victim has been proved very difficult. And this is one of the risks, not only in a small scale like work-related injuries, but also on a bigger scale. In fact, this links us to the other point, which is biodiversity and human health are in danger, because most of these companies, they create also not only human rights risk, but environmental risks as well, as has been demonstrated by the Bhopal disaster. In fact, they might use hazardous chemicals or excessive water consumption and pollution, and this affect the territory, affect the environment, which of course might have consequence on the human rights protection as well. So this whole discussion is aiming at I want to reopen the chapter, the point I made before about having a treaty on the guiding principles. So treaties, as I said, is a way to have a more enforceable rights, because you are asking member states, you're asking states to voluntarily abide to them. Unfortunately, again, the issue is how can we really, even though the state can be held responsible, how can we ask the companies to be responsible? And especially, which type of degree of fault can we require? Because we can go from just a simple negligence to stricter liability standards. The point is that the question that we should ask ourselves, what could be enough? Which type of responsibility can we ask in order to fix the corporate misbehavior? So in this way, due diligence could be used, despite has been highly criticized as being too light, as a being too soft option. But due diligence can be a way for attracting investors and consumers as well towards the more responsible realities of corporate management. So in this way, because I'm here and because I'm talking to you and I'm at the end of my speech as well, I would like to invite you to think of what you could do. You can start thinking about buying your clothes in a more responsible way. You can use apps called like Good on You, which gives you, if you download it, or if you go on the website, it gives you an idea of how ethical and sustainable some brands can be. You can buy fair trade and ethical fashion brands And again, if you do a small research online, you can find out which brands are actually respecting and promising an ethical behavior, especially in relation to the supply chains, which is the main issue. Other ideas are to focus on ethical and sustainable clothing, and as well, I put here a website in which you can have a look and discover which brands are abiding to that. But in general, what I want to conclude, I want to say that the change, if we cannot really enforce states, we cannot enforce companies, the change might start from you, from consumers. You can ask to have, you can force companies to behave in a sustainable way by deciding which companies, which are the companies in which you want to buy your clothes. So thank you so much for your presence. And if you have any question, I'm more than welcome. I'm more than happy to answer.
Thank you very much for this talk, Helga. It was very insightful, and I think it's such an important topic now. It's all over the news. It's everywhere, and I'm not surprised that we have quite a few people attending today and quite a few people interested. We have about 10 minutes for the Q&A, and I have a couple of questions for you in the chat box and in my private chat box. So if you would like to start, the first question from the attendee is, have individual states ever implemented or attempted to implement legislation on a national level, holding corporations accountable for human rights violation or some other illegal activities within their supply chain, even if they are outside their jurisdiction? And if so, what were the experiences of this type of legislation, or do you think it would be a good idea to implement such legislation in the future? So I think, yeah, I think you're muted, sorry.
Yeah. So yeah, thank you for this question. So this question, I think, requires two types of reflection. The first one is that if you have national legislation, it's still hard to check what's happening in the supply chain. So the monitoring issue that I was introducing before is still the elephant in the room. So you cannot, despite, I'm sure that some companies, they follow strictly national rules, and in the headquarters, they abide to all the ethical rules about sustainability, but it's very hard to control what they're doing in the supply chains, or if they relocate part of their production to one of the supply chains. And this actually also connects to a study I did some years ago, in which I was reading all the reports. I don't know if you are aware, but if you go on the website of this transnational corporation, you can read an annual report on their work, on what they've done. And most of the time, I mean, the most sustainable companies, they offer an overview on how they respect human rights. My feeling was, when I was reading that, my feeling was that they tend to sell this type of efforts in respecting human rights more as a promotion of themselves. And it's still hard to check and verify whether they're still doing what they're promising. So at some point, they can present their efforts in protecting the workers against human rights, but still it's very hard to verify that, even for them. So most of the time are just hollow statements in their annual report.
But would you think that this type of legislation would ever be possible, probably in the future? Do you think it would be something reasonable?
The treaty, you mean?
Yes, I think something. I think the guest is referring to the national legislation, which is trying to punish organizations for their actions outside of the state. Do you think it would ever be possible?
But this is very hard so this means that you are enforcing your jurisdiction outside your country, which is very hard to do. So you can definitely punish them if you find out, but how can you really enforce that if your supply chain is in for example in South America? How can you go there and create your it's very hard. It's about territoriality. That's why in my view, international law, it might be the solution.
Okay, I hope it answers the question. Sorry, I can see a follow-up now. So, what would you consider as a solid verification mechanism for any violation, for any whether the companies follow their corporate social responsibility practices or not? Do you think there is such a mechanism? Do you think it's ever possible?
A mechanism, sorry, can you repeat?
Sorry, a mechanism for verifying whether or not the companies are actually following their practices, their corporate social responsibility practices.
The mechanism is still the one of voluntary self-promote. I mean, voluntary offer you the information. So this is the only method at the moment that is kind of working. And I think it's working also because people are more, and again, it goes back to my point that I think we have more power than we think, we as consumers, because they try to impress the consumers by offering these annual reports, for example, in which they self-proclaim and they also address the issue. They address their own issues basically in terms of checking the respect of human rights in their own companies. So I think at the moment what is working is this self-promotion of the work they've done in terms of human rights, and because it works because people are observing that, consumers are observing that. So I think, yeah, that's the main way.
Okay. Another question I have here, do you think the companies at some point will come to understand corporate social responsibility as something which can increase their profits and improve their reputation rather than just increase cost or serve as a marketing exercise? Do you think they will ever be able to actually understand that caring about people and having a responsible supply chain is a benefit for them as a company and not just a way to attract more customers?
Yeah, I mean, this also relates back to another study I did. I did together with a business school from Vienna, in which they were trying to address the issue of human resources. I mean, of course, you need to, as a company, I suppose, you need to keep an eye, you need to take care of your human resources and the people working for the company. And if you cannot ensure certain standards, then of course this has an impact on the cost and on the incomes as well. So this has something more to do with the management of the company itself. But I definitely believe that what they're doing now with exploitation and the relocation of the companies is a short-term plan. At some point, it will become evident that it's not sustainable. That's why also we have the word sustainability. You cannot keep this going forever, especially at some point the costs and the disadvantages related to the production will be evident again, especially for consumers.
That makes sense. Yeah. Thank you, Helga. I think I can probably take a couple, maybe like a couple more questions. So the question from a person who stays in the UK, and she says that there is an event called Make It British, and fabric and supply chains are introduced to brands. So everything, all the manufacturing is done nationally and then shipped internationally. Do you think that the same problems that you mentioned with probably irresponsible supply chain can still occur here? So if it's done nationally and then shipped out?
So if I understand the question correctly, that there might still be some exploitation within the country.
Might still occur nationally.
It might be, but it will be definitely less severe than what is happening now with the relocation in developing countries. I mean, in a smaller case, on a smaller scale, this is happening already within Europe. And this is why I'm quite skeptical in terms of also connecting to your previous question that you were asking, how can we address that with national legislation? I mean, the European Union is trying to address this issue within Europe, because especially because some companies are relocating the production in East Europe, where the workforce is cheaper. So if I can compare the UK, I mean, examples that this person made to the European Union, I think it's still possible to get some advantages within the territory and try to exploit possibly some areas in which the workforce is cheaper and people are maybe more desperate to get a job, and therefore they will accept any kind of condition. The difference is that luckily we have certain standards here, certain human rights standards, especially connected to trade unions, which is something that is completely missing in developing countries. Minimum wage. So we have some securities, and therefore the risk connected to this type of exploitation is minimum. In the same way that the type of, I mean, I'm still concerned about the relocation in East Europe, because it create, maybe this could be a discussion for the next time, but it's still creating some issues in terms of human rights and also quality of the product. But I will say that definitely when you're embedding this in a legal context, which already offers some minimum standards and some minimum protection, then the risk is definitely lower.
Yeah, the example with Leicester company workers also shows that even if the human rights are protected here, fast fashion brands can still find a way to cheat the system and do something not very responsible. Helga, there is a question I think related to the supply chain. I think you can deal with it very quickly and then we can finish off. So the guest is asking, what changes do you think should be made legally and probably internally in corporations to ensure accountability of the supply chain? Again, I think it relates to what you were saying before. Do you think there's something you would like to add?
Awareness. I think definitely awareness is the answer. So we should become aware that, and we are already, but just for very few companies, we know where our iPhone is assembled. Even if is designed in California, we know that most of the production is relocated in China. And in the past, actually, I didn't mention this case because it's not strictly connected to the fast fashion industry, but there was this case of suicide of workers in China just because they were put under pressure. But I think, again, it's the awareness of the consumers that make companies changing. And that's why I believe that your initiatives to have this online conference, and all the people that are here today are an encouraging example of how we can really move forward and stop ignoring that. And maybe the next step is to change our habits and stop buying 100 t-shirts that cost £5, and maybe we can just buy one that costs a little bit more but comes from a sustainable company.